Yeah, so we can have someone, a volunteer leaders in a word of prayer so that we can start right away.
Yeah, good morning, Daktari.
Morning, Reverend. You can kindly pray for us.
Yeah, so let's pray. We come before you this morning with hearts full of gratitude for the gift of life, knowledge, and the opportunity to serve in the health sector. We thank you for this CME session organized by Nairobi TWG under the leadership of Dr. Chris, and for everyone gathered here to learn and grow. Lord, we discuss compliance with the Data Protection Act of 2019. Grant us wisdom, understanding, and may we uphold integrity and accountability in handling patient information, ensuring that every decision we make safeguards human dignity and privacy. Bless our speakers, facilitators, and participants that this session may be fruitful and impactful. We remember all those in need of quality health care, especially those living with HIV and other vulnerable populations. May our work contribute to a health system that is ethical, compassionate, and just. Be with us now, guide our discussions, and let everything we do bring honor in you. In the name of the Father, Son, and the Holy Spirit. Amen. Thank you, and back to you, Dr.
Amen. Thank you, Reverend. That's a very wonderful prayer to start the day. As has been our norm, we usually do look for experts in different fields, just to make sure that we capacity build our team that is working within our region, to ensure we not only comply with the medical guidelines, but also understand the laws that govern our practice. And one of the areas that is really currently taking shape is the implementation of Data Protection Act. I saw something from a communication from KMPDC on the same. So it's because of this we requested Gillian and Neki and Company advocates to just take us through this important CME. So without much ado, I want to invite Gloria, our colleague, who will invite a team, and then they can take over the CME. Thank you, and over to you, Gloria.
Thank you so much, Dr. Good morning, everyone. Thank you so much for being able to join us today as we talk about exclusively Data Protection Act of 2019 compliance requirements, patient and employee consent and confidentiality laws, risk of non-compliance and penalties, and finally, practical steps to ensure your healthcare practice is protected. For our presenter today, is the advocate of Law Studio Kenya, Moses Derangu. Don't mind sharing your screen so that we can begin. Moses, can you hear me? Moses?
Yes, Gloria, I can hear you. Can you hear me?
Yeah.
Great. Can you see the screen?
Yes, I can.
Amazing. Good morning, everyone. Thank you so much for your presence this morning. Today we shall be discussing data protection, the Data Protection Act of Kenya, and its application in your field, which is healthcare. I hope we have a fruitful session and that we can all learn something from this interaction. So, to begin with, the most important question might be, what is personal data and why it's important to protect it? So, the legal definition of what personal data is.
Excuse me, Moses, can you put it in a slideshow? Is it possible?
or it's minimized on your end.
Yeah.
Gloria, might you know how I can maximize the screen I'm sharing?
Go back to how you were sharing initially. Now, when you go down on your slideshow, yes, where you are, there should be an icon indicating that you can be able to zoom.
Don't seem to be able to. Would you mind presenting it for me, Gloria?
Share your presentation. All right, Jillian is sharing for you. You can, I think. All right.
Should I pause mine?
Yes, please. I see Jillian is also presenting. Jillian, are you able to put it in slideshow?
You can press where the icon on from beginning, the first part. If you can do that, we should be able to. Yes.
That is.
Good.
All right, Moses.
Thanks, Jillian. Yes, so what is personal data? As you may have noticed already, personal data is in foundational computer classes. We're told data is information, any sort of information. So personal data is defined legally in the Act as any data that identifies a person or makes a person identifiable. So what we mean by identifying a person is that you can immediately localize this individual, separating them from others and marking them or identifying them personally as an individual. So from that sort of description of what identification means, we can grasp that something like a picture, it so enables us to distinguish you from others that we can say a picture has identified you. However, something like a phone number does not immediately identify you because it's just a random set of numbers, but it's one step on the road to identifying you. For example, using your phone number, I can key it into the M-Pesa SIM toolkit, and in a couple of seconds, I'll have your name. Your name is a piece of data that distinguishes you from others. If that's not enough, we can go further than your name and obtain your image, your physical location, etc., etc., making you identifiable and, in the end, identifying you. So, having this description of personal data, why then is it important to protect it? Personal data becomes important to protect because of the way it can be used in the modern age. So, using your name and your image, a person can go ahead and find out your address, they can spy on you, they can organize theft, at your home address. They can kidnap you. Far from physical damage, using the same details such as your name, your email address, your phone number, a person can hack into accounts that are critical to you. Your financial accounts, your social media accounts, your email, accounts that are critical to your day-to-day operations and that could lead to theft and other kinds of harm. So some of the things that modern day hackers can do with your information is they can use it to access more information. Like in the example of the phone number, I can take your phone number and get your name. I can take your name and phone number and get your physical location. I can get access to your contacts, etc., etc. Having accessed this information, a malicious actor can blackmail you or your contacts. They can hack into critical accounts. They can publicize this information to your detriment. They can alter information to your detriment. They can spy on your physical and virtual habits, and they can also be a nuisance or a disturbance. I'm sure we can all attest to instances where we've received a call or a text message from a number that we were not familiar with, over a matter that we were also not familiar with. So this is an example of the sort of disturbances that can occur through a leak of your personal data, in this case being your phone number. There's various other examples where your personal data can leak and it will be detrimental to you. For example, there's some establishments where you're not allowed to take pictures so that the patrons of the establishment don't wind up in your random pictures display where they were at a certain time. The same goes for email addresses. In the modern day, with your email address, a person can access a lot more information on you, including your location, your movements, your virtual habits, the sites you visit, etc., etc. So because of these instances, governments worldwide have been forced to adopt laws that protect this data, and the laws mandate anyone who is collecting and storing such data to put in place measures to protect it. So for our use case, we're in Kenya, and the law that applies is the Data Protection Act of Kenya 2019. So the measures prescribed in the Data Protection Act tally with measures in similar laws worldwide. Some key laws would be the GDPR from the EU, the CCPA from California. Much more locally, there's the Data Protection Act in our neighboring countries of Tanzania and Uganda. There's also a data protection law in South Africa. So the measures prescribed under these acts include organizational measures. Organizational measures are put in place within the structure of your organization and are to be implemented by humans. There's also technical measures which are to be implemented on the machines and systems used by the staff at the organization. There's also policies, which are basically a codification or a writing down of the organization's commitment to protect personal data and to handle it with the utmost integrity in accordance with the law. And then finally, there's registration, which some regimes don't require registration as a mandate. There's no need for registration, but here in Kenya, registration is required of several businesses. And it's basically to let the government know that you're collecting personal data and that you've committed to protecting it and handling it in accordance with the law. So we're going to go through these one by one, starting with organizational measures, which are to be undertaken by humans. So discussing organizational measures, some of the measures that are put in place are merely giving effect to requirements in the law. One of these requirements is, for example, notification to data subjects that you're processing their data. This notification is usually done in the form of a policy or a privacy notice, a data privacy policy or a data privacy notice. If you've been on a website before and it was your first time, or maybe you are re-logging in, they usually ask you to confirm that you've read the privacy policy and the terms and conditions. Even though most times, more often than not, we don't read the policies, but the policy is there as a matter of law to inform you of the data that they collect, the way they use it, the measures they've put in place to protect it, and of the fact that you have rights over your data because of these laws. So this particular section is important for you as a member of a healthcare facility, but also for you as an individual, because basically what it means is that you get to experience this from both sides. As a person collecting the data within, as a member of the facility from within the organization, you need to be understanding how to collect and use this data in accordance with the law. But also as a user on the other side, it's important for you to know that you are, under these laws, your data is protected and there's certain rights that accrue to you because of these laws. So that's one of the measures. That's an organizational measure, because this notification can be done by handing the person the written notice, but it can also be done audibly, where when a patron checks into your facility, you let them know that in accordance with the Data Protection Act, it's our duty to inform you that we're going to be collecting this data from you. This is how we're going to be using it. These are the measures we've put in place, and these are your rights. So if you've watched movies before, you'll probably have seen, if you've watched a movie where they arrested a person, they usually recite to you what in America is known as Miranda rights. This basically means they inform you of the reason for the arrest, they inform you of your right to stay silent, to have an advocate assigned to you, or to call one, etc., etc. And if they don't do that, it's considered an illegal arrest. So this is also one of the peculiar instances where the organization is required to inform the user that they have rights, to inform them of the collection, the use, and the protection of their data, but also that they have rights over their data. A second measure under the data handling protocols is minimization of data collected and the purposes it's used for. This is found in Section 25 of the Data Protection Act of 2019, Kenya. And basically what it means is that you are required to minimize the data you collect to the bare minimum for what you need. That you mustn't collect anything you don't need, and it is your duty as a facility to interrogate whether you really need the data you collect. So this particular provision is very important, because in the technology age, and now moving into the artificial intelligence age, most organizations operate from a point of the more the merrier. The more data we can collect, the better for us. The more data points we'll have in reference, the more we'll have on you, the more marketable the data becomes. However, when you look at it from a personal perspective and not an organizational perspective, you'll realize that it will be more important to you to have less and less of your data running around with different organizations. So the lawmakers found it fit globally to introduce the principle of minimization, which means that as a facility, you should interrogate what you need, what your purpose is, what data you need to achieve this purpose, and that you should collect only that and use the data for only what you said you are going to use it for. So as you can tell, this attacks the mentality we discussed from organizations prior to these laws, where you're trying to collect as much as possible, and then you're trying to use it in every profitable way you can, rather than just using it for what you said you were going to use it for. So an example would be, as a healthcare facility, you might collect data on me, my name, my phone, my contacts, and then on to my symptoms, your diagnosis of the symptoms, and any medication you provide. Well, this data was collected to provide the service to me, the service being healthcare. A healthcare facility might be tempted to sell this data to, for example, a Google or an Amazon, so that they can now market medication to you. A healthcare facility might be tempted to sell this to local pharmaceutical companies who would also use this data for targeted marketing. So this is one of the things that is being nullified by the principle of minimization, that you should minimize what you collect and that its use should be minimized to what you had declared as the purpose for collection. I'm hoping we're all together. So third measure under data handling protocols and organizational measures is the safe collection and storage of the data you collect. So what counts as safe collection is less a matter of style and more a matter of risk mitigation. So what I mean by style is, some people might think straight data entry into computer systems is safer than handwriting and then maybe later entering it into computer systems. Well, this may or may not be true. What's more important is that in whichever way you decide to collect your data, you must make sure that you have done an assessment of any potential risks, and having done such assessment, that you have put in place measures to mitigate the risk as far as possible. So after that, you have appropriate retention periods for the data, meaning that once you've collected the data and you've stored it safely, one of the ways to further protect data is to delete it after you're done using it. So under safe collection and storage, you might decide to collect your data electronically and then encrypt it to ensure that it's safe while it's in storage. You might also decide to handwrite the data you're collecting and then store it safely in cabinets. But the law also requires you to stipulate the period for which you require the data. And once that period elapses, the law requires that you get rid of the data. So that's what we mean by appropriate retention periods. Lastly, we have access controls for staff and third-party compliance. So for access controls, what we mean is, as an organization, which in this case is a healthcare facility, there's many people operating within the organization. If you have decided that you're going to do purely electronic, your electronic systems, your computers, if you guys are using phones, there's many people within the organization, and not all of them should have access to your systems. What we mean by this is that there should be systems in place to ensure that data is accessed on a need-to-know basis. What this means is that the janitors should not have access to the computers. What this means is that a doctor in one department should not have access to patient data from a doctor in another department. Access controls basically means that personal data is going to be accessed only by people who need to access it. This goes back to the principle of minimization, where you should collect only what you need and use it for only what you need. So if person X does not need to see my personal data, there should be systems within the facility to ensure that this doesn't happen. For third-party compliance, Third-party compliance basically means that if you're going to be transmitting personal data from your organization to another organization, it is your responsibility to make sure that my data is protected on that side as well. So part of the requirements of the Data Protection Act really put a lot of emphasis on the data collectors, aka the facilities, the organizations collecting this data. That the onus is on you to notify me of the collection and my rights. The onus is on you to figure out how much of my data you need and collect only that. The onus is on you to make sure that you use my data for only what you declared is the purpose. The onus is on you to store it safely, and the onus is also on you to control its access within your organization and beyond your organization. The onus is on you to make sure my data is going to be protected if you transfer it to another organization. So that's what we have under organizational measures that you can put in place at your facility to ensure protection and safety of personal data. Once you have these measures in place, the next step is usually staff training to ensure that the staff at your facility are informed about the changes in the law and the changes in your operations that have been occasioned by the changes in the law. So for example, we've seen facilities where, in light of the provisions of the Act, they decide to do away with handwritten records and go full electronic. On top of that, they decide to use access controls where everyone needs a password to access the database where the data is stored, and that the database also has a logging mechanism, meaning it logs every instance of access, every visit, every transfer, etc. etc. Once you've done that, step 3 within organizational measures, after putting in place data handling protocols and training your staff, is usually the appointment of a data protection officer to monitor compliance with the Act and serve as a liaison between your organization, data subjects, and the Office of the Data Protection Commissioner. Now, having a data protection officer is optional. Having a dedicated data protection officer is optional. But it's usually advisable to have someone within the organization that can be answerable for any data protection concerns and that can act as a sort of prefect, someone who can ensure that the Act is being followed to the letter, and also be a consultant for people within the organization and a point of contact for people outside the organization. So that's all for organizational measures. Next, we're going to be talking about technical measures. So technical measures are now implemented on your systems. Because of the penetration of technology in all areas of our lives, technical measures become unavoidable. So technical measures basically appear in the form of risk assessment and risk mitigation. So some of the risks that would be occasioned by technical systems is obviously things like viruses and malware. These are basically corrupt pieces of code or corrupt pieces of software, which having been run on your computer, can do various things. They can spy on your computer, they can deny you access, they can corrupt other software, basically damaging a lot of data. One of the requirements of the Act is that once you've collected personal data, it becomes your responsibility to ensure that what you've collected is accurate and that it stays accurate and free from damage or deletion. So before the retention period is over, if you lose my personal data, that is actually considered an infraction under the Act. Before the retention period is over, if you alter my data if there happens to be an alteration to my data, making it inaccurate. So, for example, say I came in with a dislocated ankle, and on your systems, it converts my symptoms and diagnosis to something like syphilis or gonorrhea. That is actually an infraction under the Act. The inaccuracy of this data becomes now your responsibility, the accuracy or inaccuracy of it. So risk assessment is important, where you look at the technical systems, you ensure that you're mitigating the risks that are apparent. Things like antiviruses, things like unauthorized access, meaning a stranger like myself should not be able to walk into your facility and operate a computer just like that. So you need to have things like passwords, you need to have things like further access controls on your databases, etc. etc. So once you've assessed the risks, risk mitigation now comes in these forms: the use of security software such as antiviruses, ensuring that the software programs you're running on the computers that hold personal data are secure software programs and not malicious. Use of passwords is also risk mitigation. Encryption, which is the storage of data in an illegible form, basically converting data that is legible into mumbo jumbo. That is also a form of risk mitigation. Limitation of access to personal data to necessary parties only. This also comes in the form of passwords, the general passwords we have on our Windows, but also passwords in the database that contains personal data, where you store the personal data. And lastly, backup of personal data that you're holding to ensure recovery in case of data loss. So as you can see, if you're noting the responsibilities on you as a healthcare facility as we're going along, you're seeing that the Data Protection Act really puts a lot of responsibility on you to, first of all, ensure that your collection, your use, and your storage is in accordance with the law. But also there's the responsibility to inform me of what you're doing and my rights, as well as to ensure that the data does not get lost. Now, in this case, the use of backups, etc., etc. So these are part of the technical measures that are advisable and required of you under the Act to ensure protection of personal data. Lastly, we have the scheduling of risk assessments, which basically means that you need to regularly assess and continue assessing the effectiveness of the measures you've put in place and updating them. So the mentality has to be that there's always room for improvement, and that you can keep improving. One of the things I should mention is that one of the provisions the Act makes, because as you can tell, there's a lot of responsibility it throws onto you as a facility that's been operating however you've been operating for the years you've been operating. One of the I'd like to say leeways that the Act gives you is that it allows you to protect this data as best you can within the budget you currently have. So there's a section of the Act that states that these measures, you're allowed to implement these measures at your level, at your financial level, at your level of expertise, as long as you're doing your best within your budget. Now, as far as best within your budget, antiviruses are not that expensive. Encryption software is not that expensive. And currently, backup of personal data can be done on the cloud. So this is a leeway, yes, but you shouldn't be thinking of it as a leeway that would allow you to assume all of these requirements. It's simply a leeway that allows you to apply these requirements at your current tax bracket. So we can move on to the policies. So under the policies, these are basically written guidelines where, having studied the Data Protection Act and established what it requires of you, you now come and liquidate that into a policy for your organization. So for the first one, we have the data privacy notice. This basically informs persons of the collection and use of their data, their rights under the Data Protection Act, and the technical and organizational measures in place to secure their data. There's usually need for an inward-facing notice and an outward-facing notice or policy. So the inward-facing notice will basically set out all the things you have decided to do as a facility to ensure that personal data is protected. And this inward-facing policy will usually be handed to employees as a guideline. This is what you should be doing. The policy can also be used to train your employees. As we mentioned before in organizational measures, employee training or staff training is an important part of data protection and compliance with the Act. The outward-facing policy then communicates with your users or your clients. It informs them that you're collecting this data. It informs them of how you're going to be using their data. It informs them of the measures you've put in place to protect their data and their rights under the Data Protection Act. So secondly, we have data subject consent forms. There's instances under the Data Protection Act where you're required to obtain a data subject's consent to process their data. A data subject being your client, or you can also call them your user. So where this is required by law, you're required to have a consent form. Where consent is required, consent must be explicit. You cannot say that because they walked into my building, they consented. Consent is not always required, but where it is required, it has to be explicit. You cannot just say because they took the service, they consented, or because they walked into my building, they consented. One of the instances, just so that we can gain an understanding of it, one of the instances where consent is required is, for example, where you want to use my data for marketing purposes. So if you're going to use my image in an advert, you cannot use my image without my consent. Like, for example, images from a CCTV camera, that just because I visited your facility and you happen to have my data on your CCTV footage, that doesn't give you permission to use it in a marketing campaign, and then you come and say, I consented by walking into your building. That's one of the instances where you need a data subject consent form. I need to give you my explicit consent for you to use specific data. So again, we'll have to specify the images that you're using for marketing purposes. The third one is data subject request protocols to enable me to request for my data, because one of the rights I have under the Data Protection Act is the right to request my data. Another right I have under the Data Protection Act is the right to correction if I consider the data inaccurate. Also, the right to deletion if I feel like I no longer want you to have my data. These are also rights I have under the Data Protection Act. So here specifically, we're talking about data subject request protocols, which enables my right to request my data. So the use of this protocol is to create a system where you, having informed me of my rights under the notice, now you create a system to enable these rights, meaning you give me a point of contact or an email or a phone number that I can use to request for this data. And then internally, the protocol will then describe how you're going to go about handing me my data. Lastly, we have data breach protocols. So these are the protocols that will be set in motion in the event of a breach. One of the requirements under the Act is that you keep my data safe from malicious actors, that it should not be accessed by any malicious actors. So in the event of a breach, where now my data becomes available to actors outside of those who are supposed to be handling it, then it's supposed to set in motion some steps, including notification of the breach to me as your client and to the Office of the Data Protection Commission. So that's just one of the steps in the breach protocols, that once you've established the breach, you're supposed to notify me and the Office of the Data Protection Commissioner that there has been a breach at your facility. Other steps that will be contained in your breach protocols include an assessment of the breach and its causes, an assessment of the extent of the breach, how much data was compromised, and then the notifications and any mitigation measures that you're going to be putting in place or recovery measures. That's cool. So finally, once you have all those in place, you have your organizational measures in place, meaning you've changed the way you collect your data, you've changed the way you handle it, you have notified subjects of the collection, you've trained your staff, you've appointed someone to be your liaison, then you've implemented your technical measures, you've changed the way people access your systems, you've changed the frequency at which you do risk assessments, etc, etc. Then you come to your policies, you've drawn up your policies, you've drawn up your protocols. Finally, you register with the ODPC, which is the Office of the Data Protection Commissioner. This is a body that is set up under the Data Protection Act specifically to deal with matters data protection within the country. So registration with the regulator is, the long and short of it is, the government wants to keep an eye on you just to make sure that this law is going to, that it's going to fulfill its purpose. So other regimes have not found it necessary to mandate registration. Basically, what you have to do is comply with the other three elements we've discussed already, the organizational, technical, and policy measures. And then the only interaction between you and the government will be in case of an incident. So for example, if I feel you've mishandled my data, then I report you to the regulator in that regime. But in this regime, the government, for positive reasons, has found it fit to mandate registration. So registration basically is you informing the government of the data you collect, the way you use this data, the systems you've put in place to protect it, and it also requires submission of company accounts so that they can establish your annual revenue, which then informs how much your registration cost is going to be. So in general, organizations making less than 5 million a year or having less than 10 employees usually don't have to register. But in the third schedule of the registration regulations under the Data Protection Act, there's a list of industries where any company operating in that industry must register as a data handler. So that is a data controller and or data processor. So for purposes of registration, there's that classification of data controllers and data processors. A data controller is a facility that initiates the data collection and control controls its use. A data processor is an organization that has data submitted to it by a data controller, meaning they don't initiate the collection and they don't decide the use. They're basically a company that serves the data controller's interests and purposes. So one of the industries that's been set down for mandatory registration is healthcare, which is what has informed the notice by the KMPDC to healthcare facilities requiring them to register as data handlers by March 31st. So again, just for context, other industries in the same list include financial institutions, institutions of education, political parties, and any organization canvassing political matters, organizations in the media, and another example is organizations involved in gambling and betting and the likes. So as you can see, this list is comprised of institutions that are handling what would be considered highly sensitive data. So in the field, in the data protection field, sensitive data means something else. But in day-to-day common parlance, you can tell that sensitive data basically means that which would be critical to you. But as we discussed earlier, the tools that exist in the modern day make a lot of data critical. My face, my image is critical. My voice is critical. For example, my voice can right now be manipulated by AI to enable access to anything that I've locked with my voice. So can my image. So the institutions required to register as a matter of must are all handling data that can be deemed to be extremely volatile and can be used for the wrong purposes. So one of those industries is healthcare. All organizations operating in healthcare must register with the Office of the Data Protection Commissioner, which is basically a way for them to ensure that you have complied, rather than it's a proactive approach to ensuring compliance rather than a reactive approach, which is what I've described in other regimes where your only interaction with the regulator is in the event of an incident. So here, the regulator wants you to have an interaction with them prior to any incident, just to make sure that you are trying your best not to arrive in a position of incident. So registration charges are according to your revenue. Entities making less than 5 million in revenue or having less than 50 employees, registration costs are 4,000. For entities with 5 to 50 million in revenue and 50 to 99 employees, the registration cost is 16,000. For entities with less than 50 million in revenue, with more than 50 million in revenue and more than 99 employees, the registration cost is 40,000. Now, as an executive at a healthcare facility, I'm sure you've already been able to establish what your registration cost will be. Registration is valid for 2 years, and at the point of renewing your registration status, the cost is usually half of the initial registration cost. So for example, if you paid 4,000 to register, in 2 years you're going to pay 2,000 for renewal, and so on and so forth. The result of registration is the Office of the Data Protection Commissioner will present you with a certificate, which you can then keep at your facility just in case they do the rounds, confirming whether or not facilities are compliant. From the efforts we are seeing from the KMPDC, we can assume that they'll be working hand in hand with the ODPC to ensure compliance. And this means that your certificate of registration may be necessary for renewal of your own licenses within your own field. So that's important to note. The documents necessary for registration are your incorporation documents and certified company accounts for the previous year. So the company accounts are going to be instrumental in ascertaining what your revenue is so that we can ascertain your registration charges. Okay, so some things we should probably also discuss is the level of enforcement of these laws in the country. I'm hoping this is not describing anyone who is in this meeting with us today, but any sort of lackadaisical attitude towards compliance is currently being met with a lot of force. There has been some decided cases by the Office of the Data Protection Commissioner. So several companies have been fined, with the most recent one being Zuku, which is a telecommunications provider. And Zuku was fined 500,000 for texting a former customer promotional messages, even after the customer requested that they cease using his phone number the way they were using it, and also that they delete any personal data that they have on him. So their failure to comply with these requests by the former client has led to them being fined 500,000 as recently as 5 days ago. Before that, there were also enforcement and penalty notices against several other companies. There was a famous one against a certain entertainment establishment in Kilimani. There was also a famous one against some insurance companies, some betting companies, and a few others that we do not need to go into. But enforcement currently by the ODPC is at an all-time high. It's a fairly new office, having been established in 2023. The Act came into force in 2019. The regulations that enable the Act to perform its duties came into place in 2022. And then the Office of the Data Protection Commissioner, which is the body that's supposed to enforce the law and the regulations, came into place in 2023. So for most of 2023 and 2024, from my interactions with members of the office, they did not have enough budget to do the work of enforcement. But coming into the financial year, that is 24-25, they have been empowered financially, which means we're seeing a bit more in terms of enforcement. So yes, if you're listening to this on a personal level, you should be encouraged by the fact that there's now a law in place to protect your data, that companies have been imbued with a lot of responsibility over your data once they collect it, and even before they collect it, because even before they collect it, they're supposed to be thinking about, do we need to collect this? How are we going to protect this once we've collected it? And how they're going to enable communication between you and themselves. So that's encouraging from a personal point of view. If you're listening from the other perspective, where now you're the organization collecting this data and having the responsibility of minimizing your collection and use, protecting the data you've collected, communicating with your clients about the collection of their data. You should also be encouraged because, first of all, you have seasoned professionals, for example, from Gillian Mackey and Company Advocates, who have dedicated time to understanding the nitty-gritties of this area and offering such services. You should also be encouraged by the fact that the law has been considerate enough to require of you only what you can manage, meaning your requirement is in accordance with your budget, current technological advancements, and your level of expertise. You should also be encouraged by the fact that by being in this meeting today, it means you've caught the wave early, that you'll not be caught by surprise in the event an individual who's aware of their rights wants to exercise them in your facility. Thank you so much for your attention. If there's any questions, you can raise a hand or just type it in the chat. Let me just see. Gadi Webo David, thank you so much. Daniel Nono, is registration mandatory? Yes, for any organization operating within the healthcare space, for any organization in the healthcare industry, registration is absolutely mandatory. So this again is an effort by the lawmakers locally and the ODPC to have proactive interactions with data handlers. Proactive meaning, I want to see you before something happens. So present yourself to me, let me know that you're handling data, let me know what you're doing to keep it safe. Whereas a reactive approach would be, this is the law, this is what you need to be doing. I don't need to know what you're doing as long as nothing happens. But the minute something happens, now we've met and I'm holding you accountable. So the local philosophy is a bit more proactive, where the regulator wants to see you in advance. Thank you, Nairobi HIV RTWG. Thank you, Nelly Mbithi. Thank you, Jacob. Stephen Mulinga, is it possible? Yes, it's possible to apply for the same online. The application forms, for the application, you're supposed to be letting the ODPC know what you're collecting, how you collect it, how you store it, what measures you've put in place to safeguard it, and finally, your annual revenue. So in as much as you can do it online, doing it yourself, has its advantages and disadvantages, because some of the sections of the application forms are very technical. For example, where you need to be indicating technical measures, where you need to be indicating the organizational measures you've taken, etc., etc. For diagnostic labs. Yes, Nicholas, you can unmute, no problem.
Thank you very much, and good morning, everyone. I think this is a quite informative information that you've given us. I have a comment just to make. From what you've just told us, it sounds that most health facilities, not most actually, in health sector, these things have been already been in place. The way data is handled, it's well structured in most of the health facilities, and it sounds as if Yes, it's a policy. Government has come up with it. It's a mandatory to register with the data protection office. But again, my worry is most currently, as we speak in Kenya, health is struggling. Health is struggling such that most of health facilities are not meeting their financial obligations as it is supposed to be. Two, there is these health facilities, government health facilities. Are they also going to register with the data protection office, or they don't register? I'm asking this because I understand most of them, they also don't even register with some of the licenses that we have. Thank you.
Thank you, Nicholas. That's actually a great question. With regards to the financial position of different facilities, that's one of the reasons why the Act allows you the grace to comply at your level, meaning both budget and knowledge. The thing about that is, just like with anything else, if you really need it done, you have two options. You can either do it yourself, or you can call in someone with some expertise. So this is no different. If you're at your facility and you're saying to yourself, I'm struggling to stay afloat, I'm not trying to go out of business, and I'd like to comply with this law, you can engage a professional. You can have your negotiation on terms and the like, and they can do it for you. Also, you can do some research, figure out how to best protect yourself, and then fill out your application forms and submit them to the ODPC, who will be very candid in their response back to you. If there's anything they feel you can improve on, if there's anywhere they feel you're not going right, they'll let you know. So for me, obviously, I'd recommend getting in touch with a professional, simply because, and this will also answer your question about government facilities. Government facilities have to register. Any facility working in this in the industries that I've mentioned must register as a matter of must. So you'll notice that government universities have registered. So that's organizations in the education space. For sure, a university might have more cash flow than a hospital, but that's just to give you some perspective on compliance within the government as well. So what usually happens, and that's the reason why I'd advise getting in touch with a professional. A data protection professional comes into contact with work in one of two ways. Either A, you've called me in before something happens, I've come in, I've helped you set up, I've helped you register, we're done. Or B, you've called me in after something has happened, or I've been called in by the person something has happened to. At which point, government, organization, or private, me and you are going before the ODPC, and if the evidence is in my favor and the law is in my favor as well, it usually results in some disciplining by the ODPC. If for nothing else, just to deter further non-compliance by other people. So it's one of those cases where a naughty student is called in front of the class to be disciplined in front of the class as a lesson to him and everyone else. So you find that the cost of non-compliance will more often than not always be higher than the cost of compliance. A key example is the Zuku case we're talking about from the 15th, which is 5 days ago. Zuku have been fined 500,000 for failing to stop texting this person and failing to delete his information. Also in the infractions, they failed to give the commissioner access to their facility and to their systems. But you can see here that imagine if a professional was charging you, say even that 500,000. You see, this is a person who would have saved you the time you have spent in court leading up to this decision against you. And mind you, 500,000 so far is the lowest penalty I've seen. The establishment I'm talking about in Kilimani was fined 1.8 million. The gambling establishment I'm talking about was fined 3 million. So the cost of non-compliance, or the cost when something happens, is greater than the cost of complying. The other thing is that the obvious thing happening right now is that lawyers in the space are very predatory and very opportunistic, since they have the information that this is what your organization is supposed to be doing to comply. But as time goes on, the ordinary citizen is going to be more and more informed and therefore more empowered. Meaning, where you'd only have had a problem with one or two clients, because as a facility, I'm sure you're serving thousands and thousands of people. So whereas right now, you might have only one or two enlightened clients, because the law requires you to enlighten your clients, it means that as time goes by, we'll only have more and more enlightened people, more and more people in a position to enforce their rights, to take you before the ODPC, to try and test your temperature. So for me, that's what I'd recommend. I'd recommend within your current means, try and engage a professional to assist you with compliance with this law before something happens. Chilis. Yes. So the Office of the Data Protection Commissioner usually comes in when you've been reported to them, in as much as they have the ability to commence investigations on their own accord. At the moment, they've been slow to start such projects. So what's happening more often than not is they only interact with you when you present yourself for registration, or when they're informed of something you might be doing wrong. So for these buildings that are forcing people to leave their IDs, for me, that definitely feels like an infraction, because do you really need my ID to do what you're doing? My ID might be something disposable to me because it's something I can replace, although the cost of replacing is also a deterrent. But for sure, it doesn't seem as though they require my ID to do whatever they're doing. So in that regard, the next time that happens to you, you can raise it with them, and then you can escalate the matter now to the ODPC, at which point I'm sure they will have some comments on the same. At this juncture, I'd like to introduce Gillian, who is our team lead and a seasoned data privacy professional, just so she can also add a few comments to the presentation so far and answer some of the questions that I might have left unanswered. Gillian?
Thanks, Moses. Good morning, everyone. It's an awesome presentation. I have enjoyed being part of this discussion. I think I just wanted to clarify a few things that I've perhaps noted people are not getting clarity on. On the issue of the question that was asked about government facilities, the thing I will say is, as long as you're handling data, you need to register if you fall within the mandatory registration. I think Moses had discussed what mandatory registration industries are. So there's gambling, there's political facilitation, direct marketing, healthcare facilities, hospitality industry, and so on. So if you fall within those categories, you must mandatorily register. If you are if you're not within those industries, and then you don't have a revenue of above 5 million and you have less than 10 employees, you don't need to register. So government facilities, NGOs, charities, societies, churches, name it, they need to register. I mean, that's just the scope. The other thing I would like to clarify as well is the issue of registration cost. If you're, I know we presented and said it's 4,000, 16,000, 40,000. That is government fees. And that is government fees for one application. So Moses had clarified who a data processor is and who a data controller is. And let me just give a good example on how you'll end up needing two certificates. So I'm an employer, I run my own farm, right? And we process data. So we have clients who come, they give us title deeds, they give us, their names, their contacts, their emails, and so on and so forth. So by virtue of being we are being by virtue of processing this, collecting this data and making the decision to collect this data for the service we're providing, we're data controllers. So we need a certificate for data controller. However, in the event that I partner with an insurance firm, and the insurance firm is the one that is collecting the data, the insurance firm is the data controller. It's making the decision on what data is being collected. And then it is sending us that information to process. Let's say we've partnered with the insurance firm, for example, to do compliance of their employees, or to just do something for we are processing data on behalf of the insurance firm. By virtue of processing solely, we are data processors, and therefore we need a separate data processor certificate. So when you're looking within your organization, what kind of certificate do you need? You also need to look at your operations. Are you solely a controller, or are you a controller and processor? So if you're solely a controller, you only need one certificate, which is, depending with your bracket, 4,000, 16,000, or 40,000 for the registration. However, if you find yourself you're a controller and a processor, then you'll have to get both certificates, which now, for example, if you're in the 4,000 bracket, it will be 8,000 government fees. If you're in the 16,000 bracket, it will be 32,000 government fees, and so on and so forth. It's applied like that. So I just noted that one did come out clearly. Yeah, I think that's just that. Maybe I can answer the last question I'm seeing here. What about the NGOs? Will they register? Yes, the same thing applies. If you fall with, if the NGO is directly involved in maybe granting sub-grants or operations within a particular space, if they're in healthcare, if they're a controller or a processor, if they're within, how much money do they handle? So for them, it's not really revenue, but it's how much is, in terms of the grants, do they get in a year? Is it 500 million? Most of these people get between 3 to 6 million USD in a year in terms of grant that they're supposed to use. So again, they're supposed to register. So there is no hakuna ubaguzi hapa. It's if you're handling someone's data, and look at and as Moses said, look at it from you as a data subject. Don't look at it from you as an organization, because you'll always be playing defense. But play offense. Look at it as, it's my data. If I was going to an organization and it's my data that's being mishandled, or how would I want me to be treated? Then treat others like that. So thanks, Moses. Thanks, Gloria, for this session and for arranging this. That's all I have to say, unless there's another question that I can address.
Yeah, Jalen, there's another question in the chats. We're being asked one more quiz. Does it mean clients who go to facilities or businesses which turnover is less than 5 million, their data can be misused?
Oh, nice question. Interesting one. I love that. I hope I can unmute it. Yes. So it doesn't, so non-registration. So remember, there's the mandatory industries that you have to register. Even if you're, okay, so let me give an example of a healthcare facility. Of a healthcare facility. If you're a new facility, you need to register. If you have 0 employees, 0 patients, basically you're a building and you intend to run healthcare operations, you need to register because you're in the mandatory category. However, if you find that business is not in the mandatory category and they don't even have the revenue of about 5 million, it does not mean that the regulator or the act is allowing them to misuse their data. What the regulator is saying, or what the act is saying, is compliance with the Data Protection Act is mandatory, if you register or not. Because even if you are a company that is less than 5 million and you do something wrong as against the act, and I as a data subject report you, you will still be penalized. You will still be fined. I will still seek my compensation and I will get it. Compliance with the act is mandatory for every data handler. It doesn't matter if you're, so compliance with the act means the principles, data protection, storage, limitation, minimization, the things we've discussed about, the organizational measures and technical measures. Have you put them in place? Are you taking care of this data you're collecting and you're handling and how you're processing it? Do you have consent forms in place? Do you have contracts in place? you have a legitimate reason why you're processing that data? Like, can you be able to record all your processing activities down and show your data subject? So make sure, compliance with the act is mandatory. If you're in the registration category or not, compliance with the act is mandatory, because the cost of non-compliance, again, as Moses indicated, will hit you. So compliance with the act is mandatory. The only thing about registration is the regulator, or how the act envisioned is, let us try and cap the people who deal with a lot of data. So the assumption was, if you are making more than 50 million a year, if you have more than 100 employees, it means the amount of data that moves within your company is way more. That means we need to make sure you, of all people, are at first compliant, as opposed to someone who's running a shop somewhere in the estate with one employer or one person, and let's say a turnaround of how many people, 10 or 15 people a day. So for that person, in case they don't adhere to the act, we will catch them. But for registration, we're not focusing on them as of the moment. What is the rough estimate cost of hiring a profession to help with the registration? I will talk about how our firm does it, which is, I think, very friendly and within the market standard. So the rough estimate for registration, we usually look again at the tiers. So if you're between 5 million and 10 employees, that first year of registration, where government will charge you 4K per registration, we usually charge 40K for both controller and processor application, so to get you the certificate. If you want full-on compliance, so full-on compliance means we review your contracts, we do your employee agreements, supplier contracts. We also look at your consent form. So for example, if you have employees on your website, or you're taking photos of what is happening within your facility, how do you approach the question of consent? Because consent is always proven by the controller or processor. The burden of proof of consent is on the controller, not on the data subject. So we again look through that and develop that for you. There's policies, we can do policies for you as well. Full compliance, we do compliance training, where we inform your employees and basically do an audit of your processes as well, to see if you need to tweak some things here and there. So this is both technical audit and organizational audit on the processes. So if you want full-on compliance, it's 60K for everything. That is for the smallest tier, which the government charges 4,000 per registration. If you're in the 16K category, which the government is charging 16K per application, that one it will go to 80,000, and then there's 150,000 for the high-end companies above 50 million and above 100 employees. If you're a company like Jambojet, where you have, we did a compliance for Jambojet last year, where they have more than 15 departments, a lot of clients coming in and out. That one is on a case-by-case basis, because we have to analyze what is the scope of this audit, how long will it take, what kind of systems are we looking through. If you're that kind of facility, then that one will be on a case-by-case basis. But that's basically a standard or a rough estimate of the professional costs in this space. Gloria, I think I've answered all the questions.
Yes, you have. Unless there's anyone in the group who wants to unmute and ask a question. The floor is open. Dr. Nicholas, I hope you're satisfied with the response that you got.
Gloria, I've seen a question that's very interesting.
I'm fine, thank you.
And I would love to approach it. There's this question by Jacob Kipchilis that says, what role is the data office protecting us for this building, especially in Nairobi, forcing people to leave their IDs without signing any consent? This is a very critical area. Jacob, if you go into a building, there are some buildings that you will see they have already put a notice that says, this is a CCTV what protected area. So by virtue, the argument is, by virtue of you entering that building, you are consenting to your privacy and image rights being processed by them taking video images of you, because they have put that notice in a very visible area. The question of IDs, again, they usually argue it is for security reasons, right? But if they take your ID, and then the question about taking your IDs and not noting it down, and they return it to you for security reason, that is okay. Probably most of the times is within the privacy policy. My issue sometimes is they take your ID, they take a picture of it, or they write it down, and then the next thing you find that ID information is with someone in Kamiti prison, giving you calls and taking loans on your behalf from Tala and those. Now that is now misuse. And as a data subject, you can report such buildings, you can report such property managers for slacking, and you'll be helping in the discourse for data protection. I think that's it from my end. I hope this session has been beneficial to everyone. I will just say have a beautiful rest of your day.
Thank you so much for that, Gillian. Before I hand over to Chris, first of all, I also want to say thank you all for attending. And as we conclude this discussion on the Data Compliance Act, one thing is very clear is that compliance is no longer optional. And with increasing regulatory scrutiny, businesses and professionals handling personal data, we must all stay ahead to avoid legal and financial risks. And at Gillian Nikki Advocates, we specialize specifically in data privacy and compliance and ensuring that our clients not only meet the legal requirements, but also implement best practices for long-term security. Our expertise, you've heard from Gillian and Moses, they cover compliance audits, policy drafting, regulatory liaisons, and risk mitigation strategies tailored to your specific needs. And if you choose to work with us, with this firm, which is a proactive, knowledgeable, and committed firm, you're protecting your business and your potential data-related liabilities. So allow us to help you navigate your compliance with confidence. Thank you, and we're looking forward to partnering with you. Dr. Chris?
Thank you, Team Gillian Nikki and Company Advocate for the wonderful presentation. You've just broken down the Act to the simplest way possible, and I'm sure that my team has been able to grasp what is required of us to ensure the compliance with the law. Because the time is much gone, I will just close it at this point. But I know we're in communication with Gloria as a representative from Gillian. So we'll keep communicating. For those who will require maybe to have a signed discussion or personal discussion on matters pertaining the compliance of this law and any other law, we'll be able to provide their information so that you're able to get the assistance. So because time is much gone and we need to serve our client, we'll call it a meeting. So from myself and the team at Nairobi HIV at TWG Secretariat, I wish you a wonderful day and see you next time. Bye-bye.
Thank you. Bye.
Thank you. Bye.